Welcome to this online training resource module on the GDPR principles from Muckle LLP. The General Data Protection Regulation, or GDPR, sets out 7 core data protection principles that form the main responsibilities for organisations that control or process personal data. These are found in Article 5 of the GDPR and can be summarised as follows. First, processing must be fair, lawful and transparent. Second, data must be used only for the purpose for which it was collected. This is sometimes referred to as the purpose limitation principle. Third, only necessary data must be collected, and this is sometimes referred to as the data minimization principle. Fourth, the data which is collected must be accurate. Fifth, data must be held for no longer than is necessary. Sixth, data must be held securely. And seventh, the controller is responsible for compliance with these principles. This is often referred to as the accountability principle. We'll now look at these in detail. The first principle is expressed in Article 5A, which states that personal data shall be processed lawfully, fairly, and in a transparent manner in relation to individuals. What does this mean in practice? Well, it means that you must have a legitimate ground for collecting and processing personal data. You must be transparent about your intentions with the data subject. For this reason, organisations are required to give data subjects what are referred to as privacy notices, which set out what data is being collected, why it is collected, and what use will be made of it. You must not use data in a way that would have an adverse or unfair impact on a data subject, and you must comply at all times with the GDPR principles when controlling or processing personal data. The word fairly isn't defined, but if you are clear with a data subject as to what data you are collecting, why you are collecting it, and what you are going to do with it, and you follow this up, this is likely to be fair. The second principle, known as purpose limitation, is set out in Article 5B of the GDPR. This states that personal data shall be collected for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Further processing for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes shall not be considered to be incompatible with the initial purposes. So, putting aside for a moment the exceptions for archiving, research and statistical purposes, this means that you must set out for a data subject what you intend to use the data for, that you should only use the data that you collect for these purposes and no others, and that the purposes you collect data for must be legitimate. You won't be able to rely on the consent of a data subject to collect data for a purpose which is not legal. Therefore, if you legitimately hold personal data and want to use it in a way that was not made clear to the data subject when that data was gathered, you should seek their consent to do so, unless it falls under one of the exceptions set out in Article 5B. The third principle is contained in Article 5C, which states that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. This is often referred to as the data minimization principle. Essentially, this means that you may only collect the data you need for the reason that you have specified, and that you must ensure that the data that you have collected is sufficient for the purposes which you've collected it. This should lead you to question what data you collect. Why do you collect it? Do you really need it? Can you justify collecting the data that you are asking the data subject for? A data mapping process is a great way to audit the data that you collect and will help you think about why you need the data that you're asking for. Remember, if you don't need certain data, you are at risk by holding it, both because you won't comply with this principle and because, from a practical point of view, you'll have more data to protect and more to lose if you suffer a data breach. So, Article 5D sets out the fourth principle, which is that personal data shall be accurate and, where necessary, kept up to date. Every reasonable step must be taken to ensure that personal data that are inaccurate, having regard to the purposes for which they are processed, are erased or rectified without delay. It's important that the personal data that you hold on an individual is accurate. Some data will be subject to change, such as a list of addresses or details of people's surnames. It's for the organisation holding the data to decide when it's necessary to keep such data up to date. The Information Commissioner's Office gives the example of payroll records and a one-off order with an organisation. The payroll records will need to be kept up to date so that employees can be paid. However, whilst the organisation may wish to keep a record of the order for accounting purposes, it would not make sense to keep going back to the customer asking for their latest address if it were a one-off order. Their information was accurate when it was recorded, and there is no need to keep it up to date. The fifth principle is expressed in Article 5E, which relates to data retention periods. This principle is that personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the data are processed. Personal data may be stored for longer periods insofar as the personal data will be processed solely for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes, subject to implementation of the appropriate technical and organisational measures required by the GDPR in order to safeguard the rights and freedoms of individuals. The first point to make here is that what is necessary will depend on the reason for which the data is held. So, by way of example, a job reference from an unsuccessful applicant should be kept for at least 3 months, as a claim to an employment tribunal for a discrimination claim would need to be brought within this period. As there is no contractual relationship between the parties in this example, there's no need to retain the personal details for any longer. However, the personal data of a former employee may need to be kept for several years, as a claim in contract can be brought at any time within 6 years from the alleged breach of contract. However, to return to the data minimization principle, in this example, if an employee were to leave, you may not need to keep all of their personal data, in which case any data which is not necessary should not be retained. The second point to make is that data can be kept for longer where it's anonymized. That means where anything that would allow the data subject to be identified is removed. The sixth principle is that data must be held securely. Article 5F states that personal data shall be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage using appropriate technical or organizational measures. Measures will include encryption of data, the implementation of policies that ensure data is handled in a safe manner, training staff to understand their responsibilities and the risks that they face in handling data, and auditing security systems and processes to ensure that you are aware of the risks to your organization and you address these risks. As with many of the other principles, how this is applied will differ as between organizations. To comply with the GDPR, one organization will not necessarily be expected to implement the same measures as another. An organization should be pragmatic about the risks that they face and what they should do to mitigate these risks. Finally, Article 5.2 requires that the controller shall be responsible for and be able to demonstrate compliance with these principles. This is known as the accountability principle. Data controllers will need to be able to explain how they have complied with the GDPR and demonstrate the measures that they've taken and the reasoning behind their decisions. Examples of the accountability principle action include that data protection officers should report to the board of directors so that the GDPR is a board-level issue. Organizations should consider privacy by design, which means that privacy should be built into projects and systems rather than added as an afterthought. Organizations should carry out privacy impact assessments, which are essentially assessments of how something impacts on the privacy and security of the personal data that an organization holds. And they should also potentially appoint a data protection officer where one is necessary, and where there is no need for a data protection officer, ensure there is a point of contact or specified person or team that's responsible for ensuring compliance with the GDPR. In this sense, the accountability principle is about an organization's methodology and its interpretation of the other core principles. We hope you found this module on the GDPR principles useful. If you have any questions, would like to know more, or are interested in our other modules, please get in touch with me or a member of our team.